You're watching The Legal Breakdown. So, Glenn, Donald Trump is now asked to sever his case from the other 18 co-defendants in the Fulton County case. What does this mean?
So a motion to sever is basically a defendant telling the judge, hey, judge, I want out. I want out of the big conspiracy case. I want you to break my case out, and I want to be tried by myself. That's what a motion to sever is. And there are various reasons for defendants to want to be severed out of the bigger case. I will say the most ordinary reason, Brian, is they don't want incriminating evidence about what some of their co-defendants did spilling over on them. So if they can get themselves taken out of the case, then they can try to narrow the incriminating evidence that the prosecutors will introduce against them. And let me tell you, anytime we indict defendants together in a co-defendant case, in a conspiracy case, in a RICO case, they almost always file motions to sever, and they are almost never granted. The courts will always say things like judicial efficiency and economy dictate that you will try all co-defendants together rather than, think about it, trying 19 cases separately. Witnesses would have to testify as many as 19 times. 19 cases end to end could go on for years. So in the overwhelming majority of the times motions to sever are filed by defendants, those motions are denied.
What justification does Trump have to have this motion to sever granted? I mean, this is a conspiracy case. It's a RICO case. All of these people were part of a criminal enterprise. So inherently, there is no reason to sever him from the rest of these people because they all committed this crime together.
You're making a compelling argument for the prosecution there, Brian. That's exactly what prosecutors argue. Usually when motions to sever are filed, it's because either you don't want prejudicial spillover, incriminating evidence against more culpable defendants dirtying you up by implication, or there's something called antagonistic defenses. What does that mean? When one defendant wants to point the finger at the other defendant, and we've seen a little bit of that. We've seen some of these fake elector defendants say that they were doing what? They were working at the direction of Donald Trump. So, we were just kind of following his orders. So if we did anything wrong, it really is Donald Trump who is to blame. Those are antagonistic defenses. Now, the good news is the law says that antagonistic defenses standing alone are generally not enough to warrant a severance. And then the third reason is they say the case is so big that it will be confusing. It will be unduly burdensome for the jurors to keep it all straight. And that's another sort of lesser reason people will try to move for a severance. But Donald Trump, to answer your question directly, really none of this applies to him, at least not in as much as it would warrant a severance. He's the top dog. He's the head honcho. He's the mob boss. So I don't see him winning a severance from anybody else, but you could see a select defendant or two who's really a low man on the culpability totem pole being severed out, but I don't even think we're going to see that.
Right. This was all for Donald Trump's benefit. The idea that he would be severed out because he stands to get dirtied up by some lower defendant here just doesn't make any sense on its face. Glenn, who decides whether the Trump team's request will be granted? Is Judge McAfee?
Yeah, Judge McAfee and Judge McAfee alone. The defense will make its argument. The prosecutors will counter that argument. And based on everything I've seen thus far, Judge McAfee is likely to deny these motions to sever, but it is entirely within a judge's discretion to force co-defendants to stay together and go to trial jointly or to sever one or more out.
Okay, so we know why defendants put forward these motions to sever, and we know the mechanics of how they generally work. But in terms of why the Trump team did they do this as a way to prevent being batched in the first round of defendants, which are happening in October? Or what was the general rationale for this request?
So I think they did it for one reason and one reason only. People may be surprised, but defense attorneys will often file motions that they know they will lose. Why? Because if you make a motion and you lose it, if there is any infirmity, any shortfall, any illegality in the judge's ruling, the way he resolved the issue, then you get to preserve that issue for appeal and you get to argue it all over again in the appellate court. But if you never make the motion in the first instance in the trial court, you have forever waived the right to complain about it on appeal. So there are so many losing issues that the defense will make, knowing they're going to lose, but trying to build in some error that they think an appellate court might latch onto in the event of a conviction and remand the case, send the case back to the trial court for a new trial.
Now, I feel like I know the answer to this question, but just for clarification, are there any rules that dictate how a request to sever should be treated? Is it similar in any way to a speedy trial request where if you ask for it, it's granted generally?
No, it's really different from a speedy trial request. Here's why. The speedy trial law, particularly under Georgia state law, which is somewhat unique, says if you do not start a defendant's trial in the court session that is currently underway, and the Georgia court sessions run for 2 months at a time, or in the next court session, in this case, it would end in October, at the end of October, then the case gets dismissed with prejudice. In other words, it can never be rebrought. So that is a hard and fast rule and deadline that prosecutors must meet if they want to try the case. A motion to sever is just a discretionary call by a judge. It's not governed by deadlines or hard and fast penalties in the event the judge rules one way or another. So yes, they're both legal motions, but they're very different kinds of legal motions.
And finally, why would a motion to sever be granted to Trump if he's being charged with many of the same exact charges as the other defendants, and also that they're showing that they're able to go to trial as soon as December? Doesn't the speed of the October trial count for anything here?
Yeah, the answer is it shouldn't be granted based on the typical reasons that motions to sever are granted. It's a different matter. It's a related matter, but a slightly different matter to say, I don't want my case severed out from other defendants because there is some legal or factual reason for it, but I want to waive my right to a speedy trial. I need more time to prepare, and that's why I want what I would call a de facto severance. Listen, you may batch me together with other defendants in the future, but I can't possibly be ready to go to trial in October. It's sort of a hybrid of a speedy trial waiver and a motion to sever, but not on legal grounds, but on the ground that I need more time to prepare. But here's the thing, Brian, both defendant Kenneth Chesebro and defendant Sidney Powell have really kind of hurt their co-defendants when they make the argument that I can't possibly be ready by the end of October. If I'm Judge McAfee, I look at all those co-defendants and I say, oh no, 2 of your fellow defendants have already announced they can be ready and they are demanding to go to trial in October. So why is it that you can't be ready? Those are some bad atmospherics for the other 17 co-defendants.
Well, is that going to count for anything? I mean, is Donald Trump going to be treated then differently than any of the other co-defendants? Because now the precedent is being set in this trial that defendants can appear in court by October. So I get that Donald Trump is the big dog in this case, but he is still just another defendant as far as just these charges are concerned. So does he have any special treatment here, or is it just as simple as saying, another defendant who's just as important as you as far as, on paper is concerned, another defendant's able to go to trial in October, and so you should be too?
He shouldn't get special treatment, but he may get different treatment based on different facts. And it's going to make me break out in hives a little when I argue something to Donald Trump's advantage. But what he very well might say is, listen, Kenneth Chesebro only has a relatively small sliver of crimes charged against him in this RICO case, as does Sidney Powell. But I am the alleged head of this criminal enterprise. I have so much more evidence I have to contend with. I have so many more witnesses that I have to find and interview and prepare to trial that I may want to call in my defense at my trial. I have so much more to prepare than any of the other 18 co-defendants. I need more time. It's not treating him special because of who he is. It's treating him differently because the universe of evidence against him might be somewhat different.
Okay, well, obviously we'll follow along with this motion to sever, along with any other elements of the Fulton County case. So if you want to follow along, make sure to subscribe. The links are right here on this screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.